Mr. Attorney, perhaps it would be helpful if I were just to give reference to the case I had in mind.
Thank you very much, Malone.
It's a case called Her Majesty's Advocate and R. The report is at 2004, one appeal case is 462, and there are dicta of Lord Hope at paragraph 46 and Lord Roger at paragraph 125 to the effect that the word act in the equivalent provision to section 24 of the Northern Ireland Act does not include a failure to act. I'm not sure how helpful it is, but I said I would look it up, so there we are.
It's enormously helpful, Lord. Thank you very much. I had concluded, my ladies, my lords, by showing that the gloss given by the majority of the House of Lords in the Human Rights Commission's case had concluded that the Commission, as originally established, always had to demonstrate victim status when it was litigating. Can I invite now the Court to return to the treatment of these issues by the Lord Chief Justice? He sets out some context, and after doing so in relation to what he says is the correct approach to statutory interpretation, he picks up the discrete issue, paragraph 40, MS 8793, and says this: the First Amendment was the exclusion of section 69.5b from section 71.1 and the related addition of section 71.2a, providing that section 71.1 doesn't apply to the Commission. Prior to this amendment, the Commission was entitled to pursue proceedings for legislative incompatibility by reason of section 6.2c of the 1998 Act, although it was subject to a victim requirement. Again, ambiguity in victim requirement, does that mean another victim or the Commission itself being a victim? We say clearly it was the Commission itself that had to be a victim. Of course, the reference to 6.2c relates solely to assembly acts, nothing else. He then goes on, since the context indicates that it was the intention of the amendment to extend the Commission's powers, I consider that it would be inconsistent with that context to interpret this provision in a manner which would reduce the powers of the Commission in relation to legislative challenge. That's the core of the mistake. He fails to appreciate that Lord Hobhouse isn't right, that Lord Slynn and the majority are right, that the Commission, when bringing its own proceedings, had itself to be a victim. I consider, therefore, that section 71.1 were not intended to limit the Commission's power under section 69.5b to institute proceedings in respect of legislative incompatibility. The Commission retains its power to institute challenges to legislative incompatibility arising from section 6.2c of the 1998 Act, but like those mentioned in 71.2, it need not satisfy the victim requirement in respect of such challenges. 2 points. There is simply no basis, principal basis for exonerating the Commission from the victim requirement, that is, there must be a victim of the unlawful act. Secondly, the reference to 6.2c is of absolutely no assistance to the Commission in this case, because the only two pieces of legislation that are in the Commission's sites are an act of the Imperial Parliament, 1861 Act, and an act of the old Northern Ireland Parliament, the 1945 Act. 6.2c simply is irrelevant. And he then goes on then in paragraph 41, turning then to section 71.2b, this subsection is directed to proceedings in respect of unlawful acts and replicates the statutory scheme contained in section 7 of the Human Rights Act 1998. It is entirely consistent with the pre-existing position. Again, that's wrong. The Commission may act only if there is or would be one or more victims of the unlawful act in respect of such a claim. The subsection is silent, however, in respect to proceedings raising issues of legislative incompatibility pursuant to Section 4 of the Human Rights Act 1998. So there is we move from his conclusion, which we say is wrong anyway, in respect of Section 6.2c, which relates only to Assembly Acts, and we have the introduction here of Section 4 and the suggestion that Section 4 is somehow a freestanding cause of action provision, which we say on a proper analysis it's not. So again, the question has to be asked, who is or would be the victim of the only respondent in this case? No one. What's the relevant unlawful act? Again, on the authority in the Scottish appeal, to which my attention has been drawn by Lord Reid, again, that's not even capable of being an unlawful act for present purposes. Can I move on now to the Equality and Human Rights Commission's submission? And I hope the court has a copy of the small sheaf of authorities provided by the, if I may call them, the English Commission's submission. And can I say that the submission...
Mr. Tony, can I just pick you up on that? Does the EHRC have jurisdiction in Northern Ireland?
No, my lord, it doesn't.
It doesn't? Ah. Right, it does in Scotland.
It does.
And I had wondered if that might be an explanation for the scope of the Northern Irish Commission being confined, as you say it is. Right. Okay.
And there is a very helpful submission by Mr. Coppell, which I'm sure the members of the court have all read. We have 18 points in relation to...
Just 18?
18, yes. I'm sorry to disappoint my lord, only 18, but I'll try to go through them very quickly because I'm conscious that I don't want to encroach on my learned friend Dr. Boleyn's time.
Between you, you've got far more time than Miss Leven has to argue this point, so I think you've been quite generously treated, have you not?
Well, Miss Leven has the time that she sought, so there can be no complaint about that.
Oh, I'm not suggesting that it is.
So can I invite the court to look at paragraph 7? This is our first point. And Mr. Coppell says, although issues of convention-compatible interpretation may arise in proceedings following within Section 7.1 HRA, such proceedings, in particular where the offence in 6.2 is raised, such proceedings are not the mechanism provided for a direct challenge to primary legislation. Primary legislation is not the act of a public authority, made clear by Section 6.3 and 6.6. And we agree that primary legislation is not the act of a public authority falling within Section 6.1 of the Human Rights Act. Paragraph 8. The error here is to suggest that Section 4 conveys a cause of action. It doesn't. Section 4 never goes out alone.
Section 4 never what?
Never goes out alone. It can't. It doesn't have a freestanding existence. And I'll take the court to Lord Nichols' dictum that makes that absolutely clear in due course. Section 4 only comes into play in the context of proceedings that are already extant.
That's for anybody, not just for the Northern Irish Commission.
Yes. Respectfully agree with Liddy.
I'm not suggesting this is a proposition
Well,
for me. I'm asking you.
Well, insofar as it's a question, the answer is yes. If it was a proposition, I would respectfully agree with it. Thank you, Liddy. And in paragraphs 9 and 10, he discusses 3 cases. We look at one of them in a minute. What's common to all 3 cases is that the inter partes litigation is that proceedings were already up and running, and there were for triggering proceedings in which the court could act with respect to Section 4 of the Human Rights Act. Fourthly, and this is a point in relation to paragraphs 11 to 13, 14, when he looks at Rusbridger. Of course, here too there were proceedings. Initially a challenge under Section 7.1 of the Human Rights Act, which then morphed into an action for a declaration, relying on the interpretive obligation in Section 3, and only then the context for Section 4. Rusbridger is at Authorities Volume 2, Tab 8, MS 598. View of the time, I won't take the court to it, but of course, in any event, it's a case about Section 3, and it's a case which, in a sense, might be said not almost to survive the laugh test in the House of Lords, because it was a challenge with respect to a fanciful eventuality. Our fifth point relates to paragraph 17, and it's a major plank, it says, this is correct, of the respondent's obligation to the standing of the Commission, that Section 4 creates no new or freestanding cause of action, but is only a remedies provision to be deployed in the context of Section 7 human rights proceedings. Correct that it's not a freestanding provision, wrong insofar as we suggest that it can arise in proceedings, but proceedings that can be validly brought. Here, the Commission has brought no such proceedings, so there can be no question of a Section 4 declaration. Our sixth point relates to paragraphs 21 to 27, and this sets out the provisions relating to the English Commission's power. The short riposte is we're not going to engage in a gloss of Section 30. Nothing that I say should be taken as offering a view on how this court should approach Section 30. I respectfully agree with Mr. Coppell's invitation towards the end of the submission that the court should respectfully refrain from expressing any view on Section 30. All I ask the court to note simply is that Section 30 is profoundly different because Section 30 helpfully set out in paragraph 22 of Mr. Coppell's submission, the Commission shall have capacity to institute or intervene in legal proceedings, whether for judicial review or otherwise, if it appears to the Commission that the proceedings are relevant to a matter in connection with which the Commission has a function. So the Commission, in a sense, has competence. It can decide for itself whether it can bring proceedings. In relation to paragraph 29, these are the points on construction in relation to Section 71. Well, saying that our construction would hamper the Human Rights Commission is no answer to the argument. Properly understood, our argument forms no barrier to proper litigation by the Human Rights Commission, but even if it did, that wouldn't advance matters if that's the outcome that a proper construction yields. Paragraph 30, the short answer is we don't rely on Section 30 as an aid to the construction of Section 71. Ninth point in relation to paragraph 31, and this is the point that in a way the Northern Ireland Commission and the English Commission must go hand in hand. Well, the Human Rights Commission, as these papers show in abundance, is a body tailored to local conditions, and it is one of the outworkings of the Belfast Agreement, a process designed to bring an end to centuries, certainly decades of conflict. And the short answer is it need not be as the English Commission is. The Northern Ireland Commission needn't be, in this context, as British as Finchley. Tenthly, in relation to paragraph 32, we say that it makes perfect sense for Parliament to have prevented the Commission from bringing Section 4 proceedings by itself. Firstly, because no one else can, and the Human Rights Act structure is, as we know, generally respectful of primary legislation. And while the Northern Ireland properly set up, the compatibility of Acts of Parliament can be looked at if litigation properly sets that up. The focus of the Commission is primarily towards Assembly bills and ministerial action. Paragraph 33. Here I have to savor the compliment, at least I consider it a compliment, that we are accused of what is described as a black letter interpretation of section 69 and 71. I'm happy to accept that. It seems to me that the subtext is, you're right, but we don't like the outcome. I see here that what Mr. Coppell looks for is generous and purposive construction. Well, of course, generous hasn't been seen in constitutional law since Robinson. And we find Robinson in Authorities Volume 10 at tab 93. And I mean, naturally, I defer to the collective wisdom of your ladyship's, your lordships, in relation to the constitutional litigation that has occurred since Robinson. We certainly find a purpose of interpretation and the explicit endorsement of a purpose of interpretation, but the word generous isn't found, and there are good reasons for that. It instantly begs the question of generous to who. But there's a specific point in relation to what happened in Robinson. In Robinson, and if one goes to MS 3508, one has the legislation, section 16 of the Northern Ireland Act as it then stood. This is Authorities Volume 10, MS 3508. And each assembly shall, within a period of 6 weeks, beginning its first meeting, elect from among its members the First Minister and the Deputy First Minister. The argument for the appellant in Robinson was, well, the election has happened outside that. It can't have happened outside that. That was wrong. And the majority of the House of Lords, adopting a generous interpretation, exonerated that procedure. But in a sense, one has the view of the legislature about that. So if one looks at Authorities Volume 5 and the Northern Ireland Act, and looks at the equivalent, which is section 16A at 1476. Period for the election, it's a tighter period for election. But if one looks at 16A subsection 8 at 1477, but no person may take up office as First Minister, Deputy First Minister, or Northern Ireland Minister by virtue of this section after the end of the period mentioned in subsection 3. So the draftsman, Parliament, having suffered the generous interpretation, went back and, if I may put it this way, made it judge-proof. You can't elect them after the period. So I draw attention to that because it illustrates the importance of a truly purposive interpretation and the necessity of avoiding a soi-disant generosity. Again, 34 of Mr. Coppell's submission, we say that the Commission can still litigate, still do its job. It simply can't go beyond that. Paragraph 36 of Mr. Coppell's submission. There is no unlikely intention being attributed to Parliament. Section 71 does, in fact, increase the Commission's powers from the original position just not as much perhaps as the Commission would like or has perhaps assumed in this case. In 37, in relation to Mr. Coppell's analysis, and we say that the inclusion of section 59.5b, this being the only entitlement given then as now for the Commission to bring its own cases, has a general effect. And the perhaps the Northern Ireland focus that one does admittedly find in section 71 point away from an emphasis on a historical function. And we repeat, section 4 is not a freestanding cause of action. The Human Rights Commission couldn't bring proceedings under section 4 then, and it can't do it now. The 15th point is in relation to paragraph 37.6, and what we say is that perfectly sensibly, Parliament has enacted a provision which extends the powers of the Commission, but not to the extent that it wishes. Claimants in general who wish to rely on Section 4 of the Human Rights Act will need to already have proceedings up and running. And if one looks at the English Human Rights Commission's bundle, we'll see the dictum from Lord Nichols. It's a tab 4 of the Human Rights Commission's, English Human Rights Commission's bundle. And if one looks at paragraph 14 of the Wilson and First County Trust, one finds this. With these provisions in mind,
Page reference, please.
I'm sorry, there is no MS or supplementary MS. This again only came
this, yes.
on Monday. So it's paragraph 14, and although there is no number to that effect, it must be page 830.
Yes.
So with these provisions in mind, I turn to sections 3 and 4. It can be noted at once that section 4 rides in harness with section 3. Section 4 contains two prerequisites to the court's jurisdiction to make a declaration of incompatibility. First, subsections 2 and 4 of section 4 apply to proceedings in which the court determines whether a legislative provision is compatible with a convention right. So section 4 does not apply unless the court in the proceedings in question actually decides whether the relevant legislation is convention compliant. And then the second prerequisite is the court must be satisfied that the relevant legislative provision is incompatible with a convention right, sections 4, 2 and 4. So again, the Commission can't have brought these proceedings, and therefore there can be no question of section 4 being properly in play. In our 16th point, in relation to paragraph 37.7 of Mr. Coppell's argument, we say that the victim requirement the Commission itself has the victim requirement removed from it, but there is still a victim requirement, and the requirement to target an unlawful act remains. At 37.8, our 17th point, the reading here proposed is impermissible. The definite article in 71.2b, A and C is not an accident. This provision works perfectly well. There is no need to do anything extraordinary or forced with it. 18th point, looking at paragraph 39. Here, the alternative is the adoption. And legislation, the problem with the argument in paragraph 39 is that legislation is not an act. There is no act to which these proceedings relate. But I have to say, it's no mere formula, but the submission of the English Human Rights Commission is hugely useful in putting these arguments into relief. I said earlier in relation to an observation on the committees, the English Commission, as well as, of course, as Learned Friends, submissions on this ensure that whatever emerges from this aspect of the case will be tough law. I'm conscious that I'm in great danger of eating into my Learned Friends' time, and I simply ask the court, as I know the court will, to look at our full case and standing. But can I return finally to the word generous? The English Commission and the Northern Ireland Commission, one explicitly, the other impliedly, ask for what they call a generous interpretation of Section 71 of the Northern Ireland Act 1998. And as we've suggested, this is a claim to more than the Commission is by statute entitled to. But it's much worse than that, because generosity to the Commission comes at a cost, not only, we say, to the rule of law, but also to, in this case, in the discrete context of this case, to the lives of disabled unborn children, or to unborn children who happen to be unlucky, in this case, mortally unlucky, in their fathers. Ladies, my lords, those are our submissions, unless I can be of any specific assistance.
No, thank you very much indeed, Mr. Attorney. Dr. McLean.
Ladies, my lords, our written case on the reference can be found at MS 8590 to 8605. Much of the legal analysis that's been put forward by the Attorney General is reflected in our own submission, and I do not intend to dilate on points that he has already addressed the court in respect of. We respectfully adopt the analysis that he puts forward and seek to supplement it with some observations in respect of factual matters in relation to the Unlawful Act and some points in respect of the legal constraints on the Minister. Can I say at the outset that the Department of Justice are fully cognizant and appreciative of the functions the Human Rights Commission discharges under the Northern Ireland Act. The Commission began its interaction with the Department in this case, exercising an advisory role under Section 69(3). Its first contribution was to advise the Department in respect of international law compliance and convention compliance, and that was entirely orthodox and appropriate engagement by the Department. When the Commission embarked upon hostile litigation against the Department in November 2014, the Department protested that was an inappropriate use of the Commission's powers and protested that it did not have appropriate standing to bring the proceedings, and also that there was in fact no unlawful act committed by the Department that was worthy of being the target of the litigation. So while the Department have engaged quite properly with the Commission in the discharge of their functions, the Department has always recognised that in line with the original political settlement that gave rise to the Northern Ireland Act in 1998, the powers of the Commission were not untrammelled. Indeed, the powers of the Commission to bring legal proceedings were never intended to be untrammelled, even within the Good Friday Agreement itself. And the Lord Chief Justice in the Court of Appeal laid emphasis on the terms of the Good Friday Agreement, and in his analysis considered that that gave an expansive role to the Commission. But it is, we say, worth looking back to the agreement itself and to its text, and you will find it in the MS reference is 6144, hard copy, volume 17, and the tab is 166. The Good Friday Agreement made provision for new institutions in Northern Ireland, and there had, prior to the Human Rights Commission's creation, been a standing advisory committee on human rights, which for many years had addressed issues of this type in Northern Ireland. The Good Friday Agreement put forward a new Northern Ireland Human Rights Commission with a membership reflecting community balance. It was established by Westminster legislation, was independent of government, and had an extended and enhanced role beyond that of the original Standing Advisory Commission. Among the functions that the agreement anticipated being delegated to the Commission was that of engaging litigation. But you will see in the last two lines of paragraph 4, or 5 rather, that it was expressly deemed to be in respect of appropriate cases, bringing court proceedings and providing assistance to individuals in doing so. So it was never anticipated that the Commission would have a completely free-ranging role in respect of proceedings or litigation. It was always anticipated in the agreement that there would be some constraints on the type of proceedings that the Commission could in fact engage upon. And that, we say, was ultimately reflected in the terms of the Northern Ireland Act itself, which did not give an unconstrained right to engage in various forms of litigation. There were restrictions explicitly placed on the Commission in Section 71 of the Act. And there are reasons why there would be some constraints on the Commission and the role in which it could discharge in respect of litigation. That was in fact touched upon by Lord Hobhouse in the decision that's already been opened to the Court today, the original Human Rights Commission decision in 2002, which you'll find at Volume 2, tab 12 of the authorities, paragraph 66. The top of page MS 811. Matters which might easily be thought to be reasonable for inclusion in the Belfast Agreement may well not have been included for some political reason not apparent, subsequently to lawyers who have not been privy to what occurred. The question whether a human rights body should be empowered to intervene in litigation otherwise on behalf of a legitimate party to that litigation could be an activity with considerable political significance, so long as sectarian divisions persist. It must have been a political judgment how proactive an interventions a commission would be acceptable to the people of Ulster as a whole. So in the agreement, there was a decision taken to limit the role of the Commission. It is said in argument now, why would there be any restraints on the Commission dealing with particular areas or in the manner in which it does so? And the analysis of Lord Hobhouse reflects the fact that there may well be good reasons why in a society with deep-seated divisions and disputes frequently about human rights issues, there may be good reason to place some constraints upon that. The issue in this case, from the Department's perspective, was that we considered that there had been no unlawful act on the part of either the Department or Minister that would provide a proper foundation for this litigation. It will be recalled there could have been various targets to this litigation. There could have been a challenge brought to the Executive, for example, the Office of First and Deputy First Minister. The target that was chosen was the Department of Justice and the Minister. And the remedy that was sought was that we were being required to amend the 1861 Offences Against the Person Act. Now, that is an exercise, which I outlined in my submission yesterday, was not open to the Minister for a range of reasons, practical and jurisprudential. If I can touch on the constitutional difficulties that faced the Minister in respect of that, it might be helpful to see what actually happened in this case on the facts. And if you have to hand the second affidavit of the Department, which is in Core Volume 3, MS 9768, you will see that after the original commencement of the litigation in November 2014, the Department continued with its consultation exercise, which had already been ongoing, into fatal fetal abnormality, serious fetal abnormality, and provision for sexual crime. So that continued. My Lord Kerr earlier asked whether or not, upon the commencement of the litigation, the Minister had gone to the Executive Committee and asked whether or not he could react to the request for an amendment. The answer to that is he did not at that stage. What he did was he continued with the consultation process, which had already been embarked upon. Indeed, one of the objections the Department made to this litigation was that it shouldn't be brought while we were involved in an active process of policy formation. It was, we said, unhelpful and premature. The Minister continued with the process right through into 2015, and then he moved forward with a paper to the Executive Committee. And the Attorney General has opened to you today the constitutional constraints that apply in Northern Ireland by virtue of Section 28A of the Northern Ireland Act and the Ministerial Code. And the effect of that in practice is that a minister will not be able to effect a policy change which is controversial, cross-cutting or significant unless he obtains the approval of the Executive. The legal consequence of not obtaining approval from the Executive is that the minister has no legal authority to act. He requires the approval in order to have the authority to act. Now, that provision...
Can I be clear that the stimulus for the reference to the Executive Committee was the outcome of the consultation process,
yes,
rather than not only the launch of these proceedings, because I didn't intend, I may have done, but I didn't intend to confine my query to that issue, but also the request by the Commission before proceedings were launched that steps be taken to amend the legislation.
Yes. That didn't stimulate an immediate referral to the Executive Committee. What stimulated the referral was the conclusion of the consultation process. So whenever the Minister had a fully formulated proposal to put forward, he then advanced that in June 2015.
Was the consultation process related to the request by the Commission for an amendment of the legislation?
There's significant overlap because the consultation process was already underway whenever the Commission came in with the pre-action letters and the litigation.
Yes, but before that, before the pre-action letters, the Commission had been in contact with the Minister.
Yes.
And was that which stimulated the consultation process?
No, that was a separate exercise. The consultation process was in itself emerged from a joint position of the Department of Health and Department of Justice in response to some very high-profile, difficult fatal abnormality cases. So there was a public interest issue. It was reacted to by the Department of Justice and by the Department of Health. It was within the remit of the Department of Justice, and that's why they commenced the consultation. So essentially, the Human Rights Commission come in during that process and say, you're not going far enough. Your consultation exercise isn't addressing the breaches of convention rights. We demand that you amend the legislation now. And Minister said, not unreasonably, we're in the middle of a process. It may well deliver results that are of some utility. I want to continue with that, notwithstanding the litigation. So Minister continued with the consultation exercise, and only when he'd reached the end of that process did he bring his paper to the Executive Committee in June 2015. Now, as I've said, constitutionally, a minister cannot, in the Northern Ireland context, go on what is colloquially known sometimes as a solo run. So even if the minister had decided, I'm fully impressed with everything I've heard in the consultation, I'm going to move forward now apace with changes on serious fetal abnormality and sexual crime, he could not do that. He's disempowered. And not only that, the department in and of itself cannot do it. So we don't have a minister presently because of a political hiatus. But the department is not empowered to take that course of action either. The department must act subject to the direction and control of a minister. So what was being asked of the department required executive approval. The minister did in fact take the paper forward. That's set out in the affidavit at 9768. And the difficulty that he faced was the paper was not being included on the Executive Committee agenda. So an executive approval cannot be obtained unless the paper is put on the agenda. if the paper doesn't get to the agenda, it has no prospect of being delivered. But the safety valve for that is that there is a system known as the three-meeting protocol. So if the executive refuse on 3 occasions to take a matter on the agenda, the minister can invoke the three-meeting approval protocol, and it will be tabled for discussion. And that's exactly what happened in this case. So the Minister of Justice did, we say, everything he could. He produced the paper dealing with the consultation issues, brought it to the executive, didn't get tabled. He invoked the protocol, and it was considered in December 2015. And as is
How
noted,
did it come that it wasn't tabled?
tabling the paper is within the control of the First Minister and Deputy First Minister.
Did they decide not to table it?
They decide not to place it on the agenda. It requires a joint agreement between First Minister and Deputy First Minister to have a paper tabled on the agenda. So a matter cannot go forward at that stage unless one has the necessary approvals, which is why occasionally you will have a challenge of this type, not directed at the Minister, but directed at those who control the executive agenda.
The situation is that the Minister put this to the Executive Committee on 3 occasions, and on each occasion the Office of the First Minister and Deputy First Minister
Did not agree to table the paper.
refused to table it.
Sometimes there's debate about refusal as
Oh yes,
not
it may
agreeing.
be that they want both parties to the refusal, but in any event,
Yes.
it wasn't tabled.
Yes. The consequence of that was the matter wasn't considered until the Minister invoked the three-meeting rule. It is at that juncture tabled. And I think the Attorney referred you to the paragraph 211 in the Ministerial Code, that's MS 1628, which outlines who controls the Executive Committee agenda.
Yes.
So by this stage, our Minister, we say, has done everything he can do in order to bring the matter forward, and he has exhausted the options. Now, it was considered by the Executive at that juncture, by which stage, of course, we had the first ruling in the High Court proceedings from Mr. Justice Horner. So the litigation was catching up with the policy making process, and the Executive Committee didn't make a formal decision in respect of it. Events then moved on, and we had...
Sorry to interrupt again, Mr. McLean, but when a paper is tabled before the Executive Committee under the three-meeting rule, the Executive Committee can decide to defer any decision on it, is that right?
They can discuss and defer, yes.
And that's what happened here?
Yes, there was discussion and deferral for further information, or occasionally they sometimes delegate to a subgroup. But it's not a necessary outcome of achieving tabling that there will be a policy change. And that's where
Or even a decision on whether there should be
right.
a policy change. So what happened here?
What happened here was it was deferred, and it was brought back to the Executive on the 24th of January 2016. You see that at paragraph 6 of our affidavit. And the further paper goes to the Executive. It was not discussed again at any Executive Committee. The intervening event was the Assembly debate on the 29th of January 2016. And then the Assembly was subsequently dissolved, and we had another election, a new mandate, different minister, and the matter has sat at that juncture.
So effectively, the Executive Committee has never taken a decision on this paper.
I don't believe there's been a formal decision. Yeah. Yes. There's been no decision, there's been deferral, and what has happened, as I think I outlined yesterday, there was a fetal abnormality working group set up, sponsored by the First Minister, with the Minister of Justice, the Department of Justice, and the Minister of Health. So the fetal abnormality working group was established, which is sometimes what happens in these situations. It's gone off for consideration. They have prepared a report in late October 2016, and that awaits the incoming ministers. And that report...
Well, not only does it await the incoming ministers, but the Executive, the report of the Minister to the Executive Committee awaits decision, does it not?
The report... no, the fetal working group will report to the ministers,
Yes.
who can then take that forward to the Executive Committee. And the report will recommend modification of the law. in
Well,
respect of
quite. But just going back to the anterior position, the Minister made the report to the Executive Committee. That was deferred, and then there was a reference to the fetal abnormality subgroup. But there's been no decision on the original report by the Minister to the Executive Committee.
Hasn't been.
No. Yes, sorry. Thank you.
Mr. McLaughlin reminds me that an executive committee agenda dissolves at the end of the mandate. So we have a new executive, in theory, whenever they take their office, new ministers with as yet unallocated. So this will be business for the new ministers and executive when they come forward. But where that fits into the argument for today's purposes, we say is there's been no unlawful act by the Minister of Justice. The Minister of Justice did all he could within the law in order to address the matter. And he was constrained only by the limits of the Northern Ireland Act, which he tested to the limits. Beyond that, he could do no more. Now, in terms of the legal constraints upon the Minister of Justice, the question here is whether or not there is some legal consequence arising from the Minister's failure to act in terms of amending legislation. And this goes to the analysis of Section 6 of the Human Rights Act. And there is a bar or a protection in Section 6.6 of the Human Rights Act. Have that. Papers MS 1425, Authorities, Volume 5. So, an act does not include a failure, 6.6b, to make any primary legislation or remedial order. So what the Minister in effect was being asked to do was amend the 1861 Offences Against the Person Act. Now, he will not be making primary Westminster legislation, but it would be possible for him to sponsor a Northern Ireland Order in Council that may well have amending effect on the 1861 Offences Against the Person Act.
How does this work? I've been wondering about it. Presumably, because this is a devolved matter, is it not? So it's within the competence of the Assembly to pass legislation on this subject matter, and presumably what they could do is pass something that further defined unlawfully within the 1861 Act.
Yes, exactly.
To introduce further exceptions.
Yes.
That they could do. That's common ground that they could do that.
They could do that, and that would be within the confines of a Northern Ireland Assembly Act. So it can be done. The question is whether or not the Section 6.6b bar, in other words, that an act is not a failure to make any primary legislation, extends to what was being asked of the Northern Ireland Justice Minister. In other words, introduce devolved legislation. And the answer to that, we say, is found in the interpretation section of the Human Rights Act, Section 21, which you will see is at MS 1434 of Volume 5.
Sorry, give me that again, please.
1434, my Lord, Volume 5. So primary legislation means, you see halfway down the page, F is an order in council, amending any act of a kind mentioned in paragraph A, B or C. So any subordinate instrument in the form of an order in council amending primary legislation is to be considered as primary legislation for the purposes of the Human Rights Act. And you see there's a tail piece to that. It includes any order or other instrument made under primary legislation, the top of page 1435, and then there's a carve out for various matters, to the extent to which it operates to bring one or more provisions of that legislation into force or amends any primary legislation. So an amending instrument, the type of amending instrument that was being asked for here. Yes, be an act of the Assembly which would fall within that aspect of the...
But on Lady Hale's suggestion of an act which further defines unlawfully, that wouldn't be an amendment to the Victorian legislation, would it?
Well, again, I think we're perhaps speculating about what might be, but if it was being done by way of amendment to the 1861 Act, it would be caught by this aspect of the Human Rights Act.
Well, it'd have to be an amendment, wouldn't it? Because it would have to be confined to Northern Ireland,
Yes.
amongst other things.
Yes.
You wouldn't be,
Territorial extent
I
would
would say, for
only be
the
Northern Ireland.
purposes of Northern Ireland, this means X, Y, Z, which
Yes.
would be an amendment of the present law.
Our analysis would be it would have to be an amendment to the 1861 Offence Against the Person. And that's reinforced if one looks at the definition of subordinate legislation. Subordinate legislation means, and there's a long list of things, F refers to orders, rules, regulations, etc., except to the extent to which it operates to bring one or more of the provisions of that legislation into force or amends any primary legislation. So if it's subordinate, but it's having an amending effect on primary legislation, it's not.
Where's the except bit?
It's in brackets, my lord, at F,
Halfway down.
Oh, yes, thanks.
except to the extent to which it operates to bring one or more provisions into force or amends any primary legislation. So if it's having that kind of amending effect on primary legislation, it's not subordinate, it's primary. So there's a sort of double analysis here. And that brings one back to section 6.6 B of the Human Rights Act. So my Lord Reid asked this question earlier, and the analysis at that time in debate was what prevents the Minister from acting is section 28A.10 of the Northern Ireland Act, the inability to obtain executive approval. That's correct. In fact, that's what prevented the Minister from acting here. But even if he were able to take that course of action, then we have the protections of 6.6B coming into play. So it's not an act if he fails to amend legislation. So by either route, we say the Minister and the Department of Justice did not engage in an unlawful act in this context.
Was there any question of an application to intervene on the part of the First Minister and Deputy First Minister in this application?
No, my Lord. I think the devolution notice goes to the First Minister and Executive Office, so they would be aware of the litigation, my Lord.
But if I've understood your submission correctly, they would have been a more appropriate target than the Minister.
Well, it depends where one identifies the pinch point in the exercise. I'm identifying the pinch point as we do as much as we can, then it stops. Well, I don't know why it stops, but it stops.
Well, I think we all do know why it stops, because the First Minister and Deputy First Minister could not agree to consider the report that your client had made to the Executive Committee. And that was deferred 3 times until they could defer it no longer.
Whether or not they, in that context, would be engaged in an unlawful act, again, may be subject to the same analysis that I've just run through.
I mean, that opens up the whole array of argument again, but at least they didn't choose to intervene in the proceedings.
But we say Department of Justice are the wrong target in this case, and insofar as this goes to the question of what the Commission can do under its powers, we say we could do no more, therefore no unlawful act, and consequently the latitude that afforded by the new amendments in the Northern Ireland Act do not apply. And so for that reason, we've taken the position we've taken in our standing argument. I think those are our submissions.
Thank you very much indeed.
My ladies, my lords, as I understand it, there were 2 issues being raised. Firstly, did the appellant have to challenge a specific unlawful act? And secondly, does the appellant have standing? We deal with these matters in some detail in our reply, which is in Core Volume 1, Tab 12, MS 8758, from paragraph 43 onwards. And given that I have a relatively limited time, I would ask the court to read those submissions in their entirety. both of the arguments put against me, and I'm going to deal with both respondents together, both turn on the provisions of the Northern Ireland Act 1998. And before coming to the specific provisions, can I just deal with 2 points, or 1 point but 2 cases, on the approach to that Act, please? And first of all, if the court could again take up the 2002 Northern Irish Human Rights Commission case, which is at Authorities Bundle 2, tab 12, MS 792. I've lost my pen. Let me amend. And the court's been taken to this case on a number of occasions during the course of today, but I just want to ask the court to look at what Lord Slynn said about the commission itself and why it was set up. So starts at paragraph 11 with the commission, a reference to section 6.5b and a reference to the Commission's powers, but the passage I wanted to take you to was paragraph 12. Since the Act is for the purpose of implementing the Belfast Agreement, it is relevant to note the emphasis on the protection and vindication of the human rights of all in paragraph 2 of the Declaration of Support in the Agreement. There will, by paragraph 5 of strand 1 of the Agreement, be safeguards to ensure that all sections of the community are protected, including B, the European Convention on Human Rights, and any Bill of Rights for Northern Ireland supplementing it, which neither the Assembly nor public bodies can infringe, together with a Human Rights Commission. And then by para 5 of the section in strand 3, dealing with new institutions in Northern Ireland, it's provided that the Commission will be established with an extended and enhanced role beyond that of the Standing Advisory Committee. And I'm not sure whether Dr. McGleenan read you that, or perhaps the attorney, but you can see the words there. So my clients were a central limb of the Belfast Agreement, precisely in order to provide protection and vindication of the human rights of all. And then to take that a little further, if I can ask the court to take up the Robinson case, which is at Authorities 10, tab 93, MS 3513. And the attorney referred court to this a moment ago. 3513 is the paragraph I want to refer to. Paragraph 11 in the speech of Lord Bingham. And his lordship says the 98 Act does not set out all the constitutional provisions applicable to Northern Ireland, but it is in effect a constitution. So to categorise the 98 Act is not to relieve the courts of their duty to interpret the constitution provisions in issue, but the provisions should, consistently with the language used, be interpreted generously and purposefully, bearing in mind the values which the constitutional provisions are intended to embody. 2 points out of that. First of all, my learned friend, the attorney, seemed to criticise or downgrade the word generously. That was the word of Lord Bingham. It wasn't the word of Mr. Coppell in his submissions. It was the view of Lord Bingham in that speech that these powers should be interpreted generously, and it's clear that what he means by generously there is not generously to any particular individual or group, but generously to achieve the very purposes of the protection of human rights, which formed a part of the Belfast Agreement. And for reasons that I'll come to in a few minutes, if this court accepts the attorney's arguments, and indeed by association Dr. McGleenan's arguments, one can be fairly confident that the human rights of women, particularly those who've been raped, are not going to be protected.
There have been quite a number of subsequent cases where there's been a lack of enthusiasm to endorse what was said in Robinson. I'm thinking, for example, of Imperial Tobacco, And I think there's a more recently, I think the case about children in Scotland, Christian Institute, I think was another one where the argument was that you were supposed to give the devolution legislation a very generous interpretation, and the court has, it was Lord Hope in Imperial Tobacco, and it's been repeated in later cases, that one interprets it in the same way as any other statute.
Well, my lord, there's an element of dancing on pinheads or spectrums here. In my submission, if the court reaches the conclusion that, first of all, there is a breach of the human rights of women and girls in the situations that I advance, and secondly, that if my client can't bring an action such as this, it is effectively inconceivable. I'll make the submission now, I was going to make it at the end. Victims of rape in Northern Ireland who are made pregnant, probably victims of rape at all, are not going to go before the courts and bring an action under, say, Section 6 for the refusal of an abortion. It's completely inconceivable. The court will note from the evidence that I went through for the last couple of days, we have 3 women who've been brave enough with fatal fetal abnormality cases to put their heads over the parapet, waive anonymity and put in evidence. And that is a very brave thing for those women to have done. I know Miss Ewart's gone home, but I don't think the court should underestimate how hard it was for Miss Ewart to make that statement and go public. The court will note there are no statements from victims of rape, and that is not coincidental. And the court will remember the evidence from Mara Clark and Dawn Purvis about the situation that those women and girls find themselves in. So make no mistake, my ladies and my lords, the effect of the attorney's argument is that those women in particular, those women and girls, will not have their rights vindicated. So to return to Lord Reid's point, generosity, one person's generosity is another person's far too wide interpretation, and one can only really assess generosity and purposeness on a particular case. I am not asking for a mass, and I'll come to the analysis of the statute in a moment. I'm not asking the court to approach the 98 Act with, as it were, no regard to its words, but I am asking the court not to adopt an extraordinarily narrow interpretation which is plainly not what was intended, because it feels forced to do so despite the obvious lack of purposefulness or meeting of the mischief necessary. To answer very directly my Lord Reid's point, in my submission, one doesn't need generosity here. One hardly even, in fact, for the reasons I'm going to come to in a moment, one doesn't even need purposiveness. In fact, the attorney's arguments are simply wrong on the words. But quite, even if you weren't with me on that, in any statute these days, one looks for the mischief and the purpose. And in a constitutional statute which is being robbed of its purpose by the construction, in my submission, it is appropriate, as Lord Bingham said, to take a relatively generous approach to purpose.
Whatever the general statements may have been made about generosity or purpose, presumably you would wish to argue that you must focus on the context here. And the context here is that this was an essential part of the Northern Ireland agreement, the Belfast Agreement. And in order to give expression to that, then one needs to approach the question of any curtailment of the powers of the Northern Ireland Human Rights Commission with that purpose very much in mind.
Absolutely, my Lord. And I was going to say again, coming back to Lord Reid's point, I can't claim to be familiar with the Scottish cases that your Lordship refers to. I'm faintly familiar with Imperial Tobacco. But none of those cases were about the interpretation of the Northern Irish Act in the light of the Belfast Agreement and the specific part of, I think it's Strand 5, or it might have been Strand 3, we read it a moment ago, about protecting and vindicating human rights. So the generality of the point your Lordship makes, I don't disagree with. but there is a very specific point here about interpretation of this specific act. Can I turn from those general submissions to the Act itself, which is in Volume 5, Tab 33, MS 1540. And I'm going to deal first with the unlawful act argument and then the standing argument, although obviously there's very considerable overlap. And if I can just ask the court to see the structure of this, at MS 1539, we find Section 68, which creates the Commission. And then at 69, we find its functions. 69(5)(b), the Commission may bring proceedings involving law or practice relating to the protection of human rights. Now, in my submission, it is unarguable. It is so clear that includes proceedings under Section 4 of the Human Rights Act. Now, not sure whether the attorney's position on this has been wholly consistent through the course of this long litigation, but I have no desire to take a pleading point or look at old skeletons. The critical point is that in my submission, it is undoubtedly the case that proceedings can be brought under Section 4 of the Human Rights Act alone. There is no case that suggests that that is not right, and I'll go to Wilson and First County in a moment. If for a moment the court assumes that that is right, and that one can bring, anybody can bring proceedings under Section 4 alone, then there is no possible argument on construction, even if one took the blackest of black letters, that Section 69(5)(b) would not cover such proceedings.
Without any requirement of standing whatever, are you saying?
Well, my lord, you have to go back to the Human Rights Act to see the terms in which, in the main, if you were going to bring Section 4 proceedings, you'd have to be a victim, of course. The victim requirement's removed, as we'll see in a moment, in Section 71. But if we just take this stage by stage, the first stage in my submission is that it is plainly the case, and never been suggested as far as I know, but certainly never been accepted by this court, that it's not possible to bring proceedings under Section 4 alone. So if one goes back to the HRA itself at the previous tab, tab 31, 1421, Section 3 is, of course, the interpretive duty, and then Section 4, declaration of incompatibility. Subsection 2 applies in any proceedings in which a court determines whether a provision of primary legislation is compatible. If the court is satisfied that the provision is incompatible with the Convention right, it may make a declaration of that incompatibility. So there's nothing on the face of the statute that stops one bringing an action for a declaration of incompatibility. Now, the only, I would, like the attorney, ask the court to look at the Equalities and Human Rights Commission submissions, because they go through this matter at paragraphs 3 to 20 in great detail. But the only case that the attorney refers to, which he says supports his proposition that you can't bring freestanding Section 4 proceedings, is the case of Wilson and First County, which is in the EHRC bundle at tab 4, and the attorney referred the court to paragraph 14. I'm afraid there's no MS number, the court will remember. My ladies, my lords, in my submission, it's quite clear that what Lord Nichols there is dealing with is a different argument. He says that with these provisions in mind, I turn to sections 3 and 4. It can be noted at once that section 4 rides in harness with section 3. Section 4 contains two prerequisites to the court's jurisdiction to make a declaration. First, subsections 2 and 4 of section 4 apply to proceedings in which the court determines whether a legislative provision is compatible with a convention right, so it has to be making that determination. So section 4 does not apply unless the court, in the proceedings in question, actually decides whether the relevant legislation is convention compliant. So what Lord Nichols is saying there is, don't make a declaration of incompatibility until you've thought about whether Section 3, you can read down under Section 3. And that's absolutely conventional wisdom. You always start with Section 3 and say, can you read it down? And we have thought hard about whether you can read it down, but given the provisions of the Act here, the view that's been taken by my clients is that it is not possible to read it down. There has been an argument through the course of this litigation as to whether one could construe the word unlawfully to mean unlawfully, save where there's a breach of Articles 3, 8 and 14 of the Convention, but that seems such a convoluted argument that I found it difficult to advance it with I was going to say with a straight face, but perhaps that reflects the time of the day.
Well, initially, your proceedings did ask for an interpretive solution.
Yes.
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 And, of course, the Lord Chief Justice.
And the Lord Chief Justice
Handed you just such an one.
Was attracted to one, my lady. And at times, it's perfectly true to say, I don't think this is a point taken against us, at times we have taken the view that if a judge really wants to read it down that way, if this court really wants to read it down that way, but it creates, there are two problems. One is it's very difficult to read it down in that way, in a way that is intellectually coherent. But secondly, the solution ultimately of this litigation and what happens next must be to give women in Northern Ireland real rights and not illusory rights. And unless the law is clear, the simple fact is that obstetricians in Northern Ireland will not give the abortions because they will be in fear of prosecution. So what has to come out of all of this, ultimately, and ultimately maybe a long way away, is clarity. But coming back to the point I was actually addressing, Lord Nichols wasn't in the least bit saying you can't have Section 4 proceedings on their own. He was just saying don't make a declaration under 4 until you've thought properly and fully about 3. Wholly uncontentious proposition, often applied by this court. So in my submission, that's the end of that point, because if it is the case that we can bring proceedings under Section 4, then Section 69(5)(b doesn't, self-evidently, for the reasons that Lord Reid has given, doesn't require one to find an unlawful act. How could they? Because the very nature of the Section 4 proceedings is that you have a lawful act with a capital A. And the point that is made very clearly in the EHRC submissions is that there is a complete distinction between the Section 3 and 4 part of the HRA and then Section 6 and 7. And this brings me to Dr. McGleenan's submissions, which, with all respect to him, and however many times I've heard them, the simple answer is we aren't bringing proceedings under Section 6 challenging the failure of his client to bring in legislation for a lot of the reasons that he's advanced. That's not the cause of action. I asked this court to make a declaration of incompatibility. So with the greatest of respect to Dr. McGleenan, all this stuff about unlawful act goes nowhere because we're not bringing that action. And indeed, in respect of why we're not bringing that action, I would have thought the best advocate for that was Dr. McGleenan and Miss Patterson in her witness statement. They explain at great and articulate length how very, very difficult it has been for the department and the minister to bring forward legislation and solve this problem. Whatever target, if we had chosen a target under Section 6 and tried to judicially review that, we would have been met, A, by the defence under Section... So one possible target, perhaps in many ways the most obvious, is to judicially review the Department of Health for not providing abortions. But there's no point doing that, because we would just immediately have been met by the defence under Section 6 that they couldn't do so by reason.
What you're really saying is that they've been beating at a straw man.
They've been beating... Dr. McGleenan is beating at a...
But he was quite quick about it. And
Yes.
he just put the final
Yes. So
piece in the jigsaw,
Yes.
which the Attorney General had created.
Yes. So forget the straw man. Can I then move on, and this brings me to section 71, which on the attorney's arguments at least are relevant to issue 1, but are certainly relevant to issue 2. Does the Commission have standing to bring these proceedings? So the attorney's argument is that the Commission has no standing because of the terms of section 71, and in particular the terms, I think, of section 71(2)(b). So if we take up section 71 as it now stands, MS 1546, the court can see at 71(2) capital A, subsection 1, which is in effect victim requirement, does not apply to the Commission. And the court's already seen the purpose of these amendments. It was brought in, inter alia, to deal with the restriction on the Commission's capacity to act and to bring proceedings after the 2002 case. Court's seen that case, seen the restrictions, and if I can refer the court, I know, I think Lord Mance found it for himself earlier, the explanatory note, which is in Authorities, tab 32, paragraph 8, MS 1442, couldn't make the position clearer as to why the amendments were brought forward. So, if we look at the detail, then, of the way this works, section 71(2) capital A disapplies 1, so disapplies the victim requirement for the Commission. Section 71(2)(b) is placing some restrictions on what the Commission can do. So, it was the attorney's argument, or it may also have been Dr. McGleenan's, that the Commission doesn't have a freestanding right to do whatever it wants in respect of human rights. That's right. The restrictions exist in 2 capital B. But those restrictions, A, B, A and C, little a and little c, both refer to circumstances where there is, small letters, unlawful acts. In other words, they're about Section 6 proceedings. It's my Lord Reed's point. It would be legally inept to think that those proceedings relate to Section 4 proceedings, because by definition, there wouldn't be an unlawful act. So the simple black letter construction of this provision is that this case doesn't get near 2 capital B, because we're not alleging an unlawful act under Section 6. So the provision in question, the Commission may act only if there is or would be one or more victims of the unlawful act. That's obviously relating to proceedings under Section 6.
Section 7.
Section 7, I'm so sorry, my lady, yes. Your ladyship's absolutely right. And where that gets one to is that for the attorney's argument to be correct, what must have happened when the 2007 amendments were brought in was completely by accident and plainly, utterly contrary to the statutory purpose. What actually happened was the cutting down of the Commission's powers where Parliament intended to extend them. Now, I would suggest, without getting anywhere close to generosity, that is a construction that the court should be exceptionally slow to apply.
When you say cutting down, where do you get the powers before the amendment?
Well, so, my lord, if your lordships are with me, that section 69(5)(b) allowed the Commission to bring section 4 proceedings, that ran into the victim problem in the 2002 Act.
So effectively they couldn't bring section 4 proceedings because they wouldn't be victims.
Yes, so what the attorneys argue...
So it isn't cutting it down if that remains the position that they can't bring Section 4 proceedings.
Well, the end effect remains the same in that they would not have been able to bring them, but for a different reason.
Yes,
Yeah.
I mean when they, I mean what is put against you is, I think, that when they thought about it, they realised that in reality the only thing they had to cater for was the Commission instituting or intervening in human rights proceedings where there was another victim, and that's why they omitted any reference, for example, to legislation in 2B and 2C.
But, my Lord, with the greatest respect, that doesn't make any sense on the words of the statute. Because the words of the... If what 2B was intending to do was to stop the Commission bringing Section 4 proceedings, then it wouldn't have been referring to unlawful acts. It doesn't make any legislative sense to do it that way. And remember that the 2002...
Because the essence of a Section 4 application is that it's completely dissociated from unlawful acts.
Absolutely. That's Lord Reid's point. So that if that was seriously what they intended to do, so pre-2007, Section 69(5)(b) would have included Section 4 proceedings.
But they wouldn't have happened.
No, I'm going to come to that, my Lord. But in practice, they wouldn't have been able to bring the proceedings because they weren't a victim. I mean, one has to wonder about the 2002 case because, of course, the Commission could never... Very difficult to see how the Commission could ever be a victim. But anyway, set that to one side. So, in principle, 5B included Section 4 proceedings, but in practice, actions couldn't be brought because there was a victim requirement. What my learned friend, the attorney, has to argue is the victim requirement is amended, because it's not entirely taken away, but it's amended in 2 capital. It's taken away in 2A and then varied in 2B. So there has to be, for proceedings where there's an unlawful act, there has to be one or more, is or would be one or more victims. But by this sidewind, Section 69(5)(b) has itself been changed because you can't bring the proceedings. And just in terms of black letter law, in my submission, Section 71(2)(b) is not apposite to amend the scope of 69(5)(b).
If Section 69(5)(b) said, subject to Section 71, you might be in difficulties.
Well, I wouldn't be, my Lord, but I accept I'd be arguing it. I'd have a different hurdle to cross, but it doesn't.
I mean, the difficulty is that Sections 2B and C, especially in the light of 2C(a) little 2, appear to deal with the full scope of Section 69(5)(b), which is what previously was dealt with under subsection 1 before the amendment.
Well,
They've simply removed the full scope of Section 95(b) from subsection 1 down into B and C.
and
So-
my Lord, that's why the Lord Chief Justice read in the word.
Yes, that's why he read it in,
Yes.
it's to leave Section 69(5)(b) otherwise standing freely by itself as a sort of unregulated general power.
Well, my Lord, two things about that. First of all, in my submission, it isn't actually necessary to read the words in, but if it is necessary to read the words in, then there's an overwhelming purposive reason to do so. But in any event, in my submission, it's not just that there's nothing unlikely, it is indeed highly likely that Parliament intended the Commission, which is a public body with statutory functions and therefore not like letting an individual loose on the human rights legislation, it's highly likely that Parliament did indeed intend for the Commission to be able to bring proceedings under Section 4 without the requirement for any victim requirement. And if I ask the Court to just think about how this works, the Commission in reality can never be a victim It's very difficult to see how the law on victimhood could ever apply to a commission. So when it has a power to bring proceedings under Section 4, there is no, it makes little or no sense to say that there has to be a victim. One can see in respect of individual acts, unlawful acts, the position may be different. So there are three strands to this, and I've dealt with two. The first is that actually if you read Section 71 properly and see that 2B is only dealing with 2B, little a and little c are only dealing with unlawful acts and have nothing to do with Section 4. So that's, as it were, the black letter interpretation, no reading in. The second is that the purpose is so clear and the consequences of the attorney's argument so plainly contrary to that purpose that to the degree there needs to be any generosity or reading in, the court should adopt that. And the third is the one that my Lord Kerr made this morning, which is if one goes to 2 capital BC, self-evidently there are indeed one or more victims. If you're going to squeeze Section 4 into 2B, of course there are or would be victims of what we complain about here. You've seen their evidence. So the requirement that there would be victims is met. And that shows, is yet another reason why the attorney's argument can't be right. Because what it would mean, I think, is that the Commission would never be able to bring proceedings under Section 4.
Victims of the unlawful act.
Of the unlawful act. I mean, it doesn't actually make sense because there isn't an unlawful act. That's why my first...
Oh, it doesn't make sense if you grant your premise.
No, I agree, my Lord, but I'm trying to see it from every possible perspective. In my submission, the best perspective is the black letter one, and you never get to Cap 2B. If I had to choose an argument, I would choose my Lord Reed's. You just never get there. That's the sensible construction.
Can you help me with 2C of 71, where it specifies separately Section 71B and 69.5B, both sets of proceedings brought by the Commission. 71B covers the individual, the victim, as it would normally be. 69.5B?
So section... Yes, oh, sorry. Yeah. So I think the way this works, so section 69.5B is the provision that we've been looking at.
Yes, but why do they specify it separately?
Oh, I think, my lady, because what 2CA Roman 2 is dealing with is interventions.
Yeah. Right.
So if you go back to 7.1b of the Human Rights Act, which is at MS 1426,
yeah.
That's where a person who claims a public authority has acted. So that's where the individual starts the proceedings.
Yes.
And then the Commission, because if you go back to 71.2b, it's in relation to the Commission's instituting or intervening in human rights proceedings. So Section 69.5b is when it's their own proceedings, Section 7.1b is when they're intervening. And so finally on the purpose, in my submission, the attorney's construction would seriously restrict the Commission's ability to do its job. If it couldn't challenge legislation in circumstances where, for whatever reason, and one can imagine in the context of Northern Ireland there might be quite a lot of different reasons, individuals don't feel they can bring actions. And the Commission wants to challenge a piece of legislation, then the effect of the attorney's argument would be seriously, potentially, well, in this case it's not potential, but generally seriously detrimental to the vindication of human rights, the protection of human rights. And I've already made the submission. The attorney in his submissions this morning said it wasn't necessary to read down or to construe in the way that that we have suggested. And that, well, he just said the words, it was not necessary. I ask the court to consider how very necessary it is on a fact such as this, because without the Commission bringing this matter, victims of rape and incest would not do so. It's not that they could not do so, but they would not do so. And so can I end by calling a spade a spade? What the attorney is trying to do here is to shut out victims of rape and incest. He's trying to make sure that that issue does not come before the court. And in my submission, the court should not let him have that position. Anything else? My ladies, my lords, those are all my submissions, unless there's anything else I can help the court with.
No, thank you very much indeed, Ms. Leaven.
Ladies, my lords, very briefly. Firstly, it should be remembered that the agreement context, that is the Belfast Agreement context for the Commission, is that it should be able to bring cases, inappropriate cases. That is a quotation from MS 792. There is absolutely nothing in the Belfast Agreement which says that they should be able to bring this kind of case. There is therefore no curtailment.
Why is this an inappropriate case?
Because it falls out with the Commission's capacity. Appropriate is the loose term used in the Belfast Agreement, and it has been left to the legislature to define it. There was no suggestion when the Northern Ireland Act was originally enacted that in some way faith had been broken with the Belfast Agreement in the terms of Section 69 and 71, even as originally enacted.
But one was standing in the position of politicians or lawyers at the time that the Belfast Agreement was made, and one asked oneself, what are appropriate circumstances for the Commission to bring proceedings? I ask the question again, what's inappropriate about taking proceedings like this? Does it not go to the very heart of the protection of human rights?
No, my Lord, with respect, it doesn't, because at the core of protection of human rights is a concern with the rule of law. And the rule of law, among other things, requires that public authorities, whether they be prisons, courts, or human rights commissions, stay within the bounds of the law that apply to them. And this Commission has gone beyond the bounds that Parliament has set. So there is no curtailment of the Commission's standing. In fact, the Commission's standing since the 1998 Act was originally enacted has been enhanced. We emphasise not as enhanced as the Commission wishes or thought that it had been. On generosity, MS 3513, of course, generosity is simply question-making. Your ladyship's and lordships have our submissions on that. If one goes again to tab 4 of the English Equality and Human Rights Commission's small bundle, and to Wilson and First County Trust, can I emphasise simply a word in what Lord Nicholl says in paragraph 14. That is the court's jurisdiction to make a declaration of incompatibility. The use of the term jurisdiction is absolutely inconsistent, as of course is the text generally of Section 4, with that being a provision which creates a cause of action. It's a remedies provision. And the House of Lords in Wilson and First County Trust clearly thought so. But even if we're wrong about that, and Section 4 is contrary to our analysis of that statutory text and inconsistently with the judgment of the House of Lords in Wilson, even if other people can do it, the Commission can't. Because if you look back again at Authorities Volume 5, 1547, the only human rights proceedings that the Commission can take, this is 2C, are proceedings under Section 69(5)(b), or as Lady Black has pointed out, 7(1)(b), which, in respectful agreement with my learned friend Ms. Leaven, is that situation where the Commission intervenes in proceedings that are already extant. Section 4 simply isn't there. So even if, contrary to our general submission, others can, the Commission can't. And finally, there might be room for some of the Commission's submissions on this issue if 2B, 2C simply didn't exist. If the matter was simply left at large, if the legislature had enacted 2A only, there might be room for manoeuvre. But in the creation of a detailed lex specialis governing capacity, there is no room for doubt, we respectfully submit, and the Commission in the present proceedings has fallen out with that. And as to the idea of this being some sort of horrible mistake, and that really this has nothing to do with the Justice Minister at all, well, really the Commission ought to extend a heartfelt apology to the Justice Minister of the time. But the reality is, he was and is the only target of this litigation. And he created no victims, nor was in any danger of creating victims. My ladies, my lords, thank you.
Thank you very much indeed, and thank you to everybody who has put submissions before us in this very difficult and sensitive case. We're grateful to all the interveners. We tried to be as even-handed as we could in acceding, I think, to every single application that we had for an intervention. So we have, of course, read the written submissions of those who've intervened in writing only, and we take those into account along with all the interesting debate that we've had over the last 3 days from all counsel and those sitting behind and beside them who've no doubt been of huge assistance to them. Well, I've observed it happening in the course of the hearing. So thank you all very much indeed. We will now go away and try and work out the answer to these difficult questions. Thank you. Court is now adjourned.